We are coming close to the end of our series on the amendments to the Constitution. We've been doing this for a little over a year, looking at the amendments to the Constitution, what was going on at the time, what were the amendments about, and how has that changed our government as we move forward. This is all part of the United States Capitol Historical Society's meeting our mission to inspire informed patriotism. The United States Capitol Historical Society was chartered by Congress to tell the story of the history of Congress, of the Capitol, and all who work in it. And this is what we do every day in civic education, in public history. And we are so grateful, Professor Kalt, that you have joined us today. So let me tell you about what we're talking about today. There were 3 amendments that changed the presidency: the 20th, the 22nd, and the 25th amendments. Professor Brian Kalt, we always call him doctor because he's a professor, although he's a juris doctor, and lawyers don't go by doctors. There's all this conversation between lawyers and doctors. What can we say? Professor Kalt is an expert in constitutional law related to the presidency, and he is here today to help us understand what those changes were and why they were needed and how they changed the presidency. Interestingly, these amendments have all been passed in the 20th century. In 1933, the 20th Amendment moved the date of the presidential inauguration to January 20th. Prior to that time, presidents got elected and had to wait until March to take office. In 1951, the 22nd Amendment, which required that presidents could only serve 2 4-year terms. This came following the FDR reign as president. And in 1967, the 25th Amendment was to establish clear constitutional parameters for presidential succession. This took a while, but it came in the wake of President Kennedy's assassination. Now, let me tell you about Professor Kalt. He and I share an alma mater at the University of Michigan, although he is now a Michigan State professor. So there's a little bit of that in-state rivalry. Before he came to the Michigan State Law School in 2000, he served as a law clerk for the Honorable Danny Boggs at the Court of Appeals of the Sixth Circuit, and as an associate in the Washington, D.C. office of Sidley Austin. His research focuses on structural constitutional law, especially provisions concerning the presidency, elections, impeachment, pardons, and the 25th Amendment, and on juries. And we would invite our audience, you can ask him about any of those things, even though we're talking particularly about these amendments. Professor Kalt has appeared numerous times on national television, written for the Washington Post, the Wall Street Journal, the Atlantic, and we are so grateful to have him with us. In addition to teaching at MSU, he's been a visiting professor at the University of Alabama and the University of Ottawa, as well as a visiting lecturer at a university in Lithuania, which I must admit I would not properly pronounce. His law review article on the impeachment of ex-presidents was cited by both sides during the second impeachment of President Trump. So he is clearly one of these scholars that we always search for, who tells the history as it is and lets people make their own determinations. We are going to move to our traditional pattern of having Professor Kalt present his information. As Vincent told you, any of you have questions, please put them in the Q&A. I will field those during the Q&A period once Professor Kalt has finished his presentation. We are grateful, Professor Kalt, that you have come to us and that you have offered your services to share information for our dedicated audience. Take it away. Tell us about the Constitution and these amendments.
Well, thank you so much, Jane, and to the Society for inviting me. I love talking about this stuff. I love writing about this stuff. A lot of what I say today will draw on some articles that I've written on the 20th Amendment. My last book was on the 25th Amendment, and the one before that was about several presidential constitutional issues that some of them come up here. So when most people think about constitutional amendments, the first thing that comes to mind is amendments about rights. These are certainly the ones we hear the most about on TV and in courtroom dramas, but the constitutional amendments that deal with the structure and the procedures of the federal government are very important too. And so I'm always personally more interested in those, and the ones I'm talking about today, the 20th, the 22nd, and the 25th, are great examples of that. And I'll just get right into it. I'll go in order, start with the 20th Amendment. It passed Congress in 1932, was ratified by January of 1933. The core of the amendment dealt with Congress and the presidency, and it was intended to reform the awkward calendar with which they had been saddled, because the original Constitution said how long their terms were: 2 years in the House, 4 years for the president, 6 years in the Senate, but it didn't say anything about the precise date that they would start. So after the Constitution was ratified, the outgoing Articles of Confederation, Congress declared March 4th, 1789, as the beginning of the new government. And that set the beginning and end of all of the terms, March 4th. But the Constitution did specify that Congress had to assemble at least once a year, and that they do that on the first Monday in December, unless they chose a different day by statute. So before the 20th Amendment, we had a strange schedule. Once Congress established the Uniform Election Day, federal elections were held every other November. Then the next month, on the first Monday in December, the lame duck Congress would convene for a session lasting up to 4 months until the end of the term on March 4th. And then, unless the president called a special session, the new Congress wouldn't convene until the next December, which was 13 months after it had been elected. And this, over the decades, led to a lot of complaints. It seemed ridiculous that half of the congressional sessions would feature lawmakers who may already have been strongly rejected by the voters. And if the voters made a strong statement in the election, it also seemed ridiculous to make the new Congress cool its heels for 13 months before they could get in and start responding to the voters' mandate. And this came to a head in the 1922-23 lame duck session, and Senator Thaddeus Caraway introduced a resolution calling for members of Congress who had just been defeated for re-election to not take part in anything consequential. This resolution got sent to committee, and Senator George Norris in committee transformed it into a constitutional amendment proposal, what would become the 20th Amendment, moving congressional terms and presidential terms back to January instead of March, and starting the congressional sessions in January at the very start of the term. So with this proposal, there would be a first session that started 2 months after the election, not 13 months after. Then there'd be a second session that opened 10 months before the next election instead of 1 month after it. And turning to the presidential part, though that's the rest of the amendment, Norris's proposal also decoupled presidential terms from congressional terms. Remember, initially they all started on the same day, March 4th. And Norris wanted to set the congressional term to start a couple of weeks before the presidential term. And this was mainly because of so-called contingent elections. That's when no one wins an electoral college majority in the presidential election, and so the election gets thrown into the House, or for the vice presidency, thrown into the Senate. Back then, before the 20th Amendment, if the presidential election got thrown into the House, it would be the outgoing lame duck House that would select the president. And Norris wanted the new House to make the choice because it would have a fresh mandate from the voters. But doing that required that the presidential term start later to allow some time for that to happen. So those changes, starting the starting dates of the terms, the starting dates of the congressional and presidential terms, and then the congressional sessions, that became sections 1 and 2 of the 20th Amendment. But it took a while. Norris's 1923 proposal sailed through the Senate by an overwhelming margin, but it died in the House. Despite having a lot of support there, the House leadership wanted nothing to do with changing the status quo. The lame duck sessions gave them a lot of power. Norris tried again in 1924 in the next Congress, and again, it sailed through the Senate, and again, the House leadership killed it. But this time, before they killed it, some important work was done in committee in the House, work that would become sections 3 and 4 of the amendment. And those are the ones that I have written the most about, or am writing about. The House committee basically said, well, look, while we're rethinking all these timing issues, we really should fix some other related nagging problems. We don't get a lot of chances to amend the Constitution, so let's do all this at once. Things that had never really come up, but would be bad if they did. So remarkable foresight and proactivity by the Congress. One of them concerned a gap in the Constitution's coverage of presidential succession. The original Constitution says, if something happens to the president in the middle of the term, the vice president steps in. If something happens to both of them, Congress can legislate a line of succession to tell us what to do then. But it didn't say, the Constitution said nothing about when something happens between the election and Inauguration Day. And so the House committee said, let's extend the Constitution's coverage to this pre-inaugural period. So now, if something happens to the president-elect, the vice president-elect will step up. And if something happens to both of them, well, Congress can pass a succession law to provide for that situation. And that became Section 3. Finally, Section 4 dealt with a scary issue regarding contingent elections. So the Constitution was specific that if a presidential election gets thrown into the House has to choose from among the top 3 electoral vote getters. The problem with that was that if a candidate, one of those 3 dies, the Constitution didn't have any way to replace them. This was on everyone's mind because Senator La Follette, he had run a strong third-party campaign in 1924 and then died shortly after the election. People were thinking about it, at least enough to get it into the bill. At every other point in the presidential process, you can make replacements, right? If the president dies, you get the vice president, his chosen running mate. You don't do a new election. You don't give power to the runner-up in the election. And if a candidate dies or drops out before the election, the party can name a replacement then too. We don't say, well, I guess they're just out of the election now. So the House committee added a section, which became Section 4, saying that Congress could pass a law to cover that situation, the death of a candidate in a contingent election. The House leadership kept killing these resolutions, though. So for the next few Congresses, the pattern repeated. The Senate would pass Norris's version with Sections 1 and 2. Then the House committee would report out its improved version with Sections 3 and 4, and the House leadership would kill it. The logjam didn't break until 1931 when the Democrats finally took over a majority in the House and the new House leadership let the resolution come to a vote. It passed. The conference committee reported out the version we have today with all 4 sections. And so sections 1 and 2 went into effect. That's why Congress starts in January. President swears in 17 days later on January 20th. Despite the intention, though, of eliminating lame duck sessions, we do still have them. They are shorter now, at least, but aided by the invention of air conditioning, Congress no longer ends its sessions in time to beat the heat in the summer, and instead the sessions tend to run all the way until the new ones start in January, or at least close to that. Section 3 about pre-inaugural succession was worded in a way that gave Congress a lot more flexibility than it has for regular succession in the middle of the term. And that's good because you might want a different line of succession for pre-inaugural situations, and you might want several different ones. You might want one for a double death, one for a temporary disability, yet a third for an election that's still disputed when January 20th rolls around. But Congress never used that flexibility. It didn't pass anything at all under its Section 3 power until 1947, when it overhauled the regular line of succession. That's 1947 is when they passed our current statute, which puts the Speaker of the House next in line. And Congress just applied the same line of succession to all of the pre-inaugural, post-inaugural scenarios. It just opted for a one-size-fits-all solution. And then Section 4 about this dangerous situation of a finalist in a contingent election dying. Well, it's been 81 years now, and Congress has never passed such a law, which is unfortunate because if a death like that ever did happen, it would be very hard to fix things on the fly. Turning now to the 22nd Amendment, this, of course, limits presidents to 2 terms, or it mostly does. More on that in a second. The 2-term tradition was well established. It started with George Washington. It was very important in shaping our republic. Washington probably could have been president for life had he so chosen. That would have started things off on a very monarchical foot. We take it for granted now that our presidents aren't presidents for life, but Washington's decision was really crucial. Jefferson, Madison, Monroe, Jackson, they all respected the 2-term tradition. The traditional story is that it was set in stone by Washington and then shredded by FDR in 1940. That's not quite right. After the Civil War, we had some 2-term presidents, and they all sort of made noises about a 3rd term. Ulysses Grant served 2 terms and then left, but in 1880, he made a strong run for the Republican nomination. He actually led on the first 35 ballots. He couldn't get an outright majority, so they picked James Garfield as a dark horse, but the 2-term tradition wasn't what was holding him back. It was divisions within the party on other issues. Theodore Roosevelt ran for a 3rd term in 1912, having served out most of McKinley's 2nd term and then being elected to a full term in his own right. He ran as a 3rd party candidate, finished 2nd, and again, the 2-term tradition didn't look all that set in stone. President Cleveland flirted with a 3rd term. President Wilson wanted a 3rd term until they talked him out of it because he wouldn't have won. And during this time, numerous constitutional amendments were proposed to limit presidents to 2 terms, but none of them went anywhere. It wasn't until the FDR breach that things moved along. Conditions in 1940 were perfect for a breach. It was in the middle of the war. We weren't in the war yet. Anxious voters in the still neutral United States put a premium on keeping Roosevelt at the helm. Privately, he wanted a 3rd term. Publicly, he was demure. And the main problem was the Republicans had a popular candidate in Wendell Willkie, and the Democrats had no one remotely as compelling as Roosevelt. So they nominated him. Willkie pressed the 3rd term issue, warning that it was a prelude to dictatorship, which in 1940 was a pretty powerful image to evoke, but to no avail. Roosevelt won easily, and in 1944, he easily won a 4th term. But after he died in 1945, the Republicans retook the House and Senate in the next elections. And in January 1947, on their first day in power, Republican leaders introduced the 22nd Amendment to limit presidents to 2 terms. Depending on whom you ask, this was either out of a public-spirited policy concern about presidents staying in power for too long, or it was a dig at the late President Roosevelt, defeating him in spirit after the failure 4 times to defeat him at the polls. And maybe it was a little of both, but regardless, it passed both houses pretty easily. The states weren't exactly thirsting for term limits. Ratification took almost 4 years. In fact, it was the longest any amendment has ever taken to be ratified, other than the 27th Amendment, which took almost 203 years. That will be a great talk all by itself, but it was eventually ratified by enough states in 1951. I want to talk a little bit about the precise wording of the 22nd Amendment, though, because some people have argued that there's a loophole in it, and this was the subject of Chapter 6 of my book, Constitutional Cliffhangers. The amendment starts out simply. It says, no person shall be elected to the office of the president more than twice. And then it goes on at at length with some convoluted language about people who weren't elected president but succeeded to the office, or they served as acting president, and did so for more than 2 years out of the term. So people who do that, like President Ford, who served out more than 2 years of Nixon's second term after Nixon resigned, people like that are only allowed to be elected once. People like President Lyndon Johnson, who served out less than 2 years of Kennedy's term, they're free to be elected twice. Now, I said there's a potential loophole. Ironically, the loophole doesn't come from that convoluted part. It comes from the simple part. The common understanding of the 22nd Amendment is once a president has served 2 terms, he's out. But that's not what it says. It says no person shall be elected president more than twice. And we know that being elected president isn't the only way to become president or acting president. So here's the loophole. Hypothetically, could a 2-term president be elected as vice president or appointed vice president, as we'll talk about the 25th Amendment process, or be farther down on the line of succession? And then if something happened to the new president, ascend to the presidency for a 3rd term. That might sound a little contrived, but people in 1960 talked seriously about Eisenhower running for vice president as Nixon's running mate. Eisenhower was term limited, but Nixon was very young, and people thought, well, maybe it's a good idea. The same talk has arisen over Clinton and Obama, if less seriously. More worrisome, though, is that term limits around the world have been proven to be very vulnerable. And I talked about this in my book, how a would-be dictator could exploit this loophole to back himself into the presidency even after serving 2 full terms. Some of you might be familiar with the last line of the 12th Amendment, which says, no person constitutionally ineligible to the office of president shall be eligible to the office of vice president. But that just begs the question, are 2-termers eligible to the office? The loopholers would say, well, they can't be elected president, but they can be president. So they are eligible to the office of president and therefore to the office of vice president. Now, when the text gives us an opportunity for mischief like that, then we have to look at the history. But if we look at the history, it further bolsters the loophole interpretation and tells us what I think is an interesting story about constitutional drafting. As originally written, the amendment was conscious of the loophole and it guarded against it. The first version of the amendment introduced in the House talked about someone being chosen or serving as president or being eligible to hold the office, not just being elected, but to hold the office. And the House passed language that was more concise, but had the same effect, ineligible to hold the office of president. That still left a little loophole for acting presidents, but it went to the Senate, and the Senate Judiciary Committee closed 2 loopholes. One, they made it clear that service as acting president would count toward the limit or succeeding to the office. So that's when they started talking about, well, you weren't elected president, but you served for more than a certain amount of a term. Let's count that as one of your 2 terms. And then they said, shall not be eligible to hold the office of president or to act as president for any part of another term. So there was no loophole. And then at that point in the debate, Senator Warren Magnuson spoke up and said something very ironic. He wanted the amendment to use more straightforward language to avoid what he called, quote, complicated legal questions. He said that the Judiciary Committee's language was very complicated. He said that he, quote, doubted if many state legislators could really understand its wording, unquote. So he proposed that the amendment simply provide no person shall be elected to the office of president more than twice, unquote. And that language was popular. They adopted that new language. It's what's in the amendment. But there are 2 ironies here. The first is that the whole problem was caused by his desire to avoid complicated legal questions, but that's his language is what opened up these loopholes. And the second irony is that he did this to have concise, simple language, but the Senate wanted to make sure that they covered those partial terms, so they added back in the provision about counting a term against your total. So Magnuson's elegant and concise 13 words ended up ballooning out to an amendment that was the current 121 words, and the loophole remained. At this point, I want to harken back to something I said about the 20th Amendment, which is that it allows the pre-inaugural line of succession to be much more flexible than the regular line of succession, if Congress so chooses, in the line of succession law. So let's imagine there's a disputed presidential election. Both sides are fighting it out in court and in Congress, and January 20th is going to roll around without a winner selected. The 22nd Amendment loophole would allow Congress to pass a law allowing the incumbent president to stay in power for as long as it takes to resolve the election controversy, which I submit is a bad idea. Even if the letter of the 22nd Amendment allows the president to stay in office after his 2 terms are up, the spirit of the amendment and the spirit of our democratic republic isn't very comfortable with using a backdoor like that for a president to stay in office potentially indefinitely. They could also amend the line of succession statute that says if the president-elect and vice president-elect both die or resign, maybe they both resign because they were just stalking horses for the incumbent, then they could say the line of succession is the incumbent stays in. All you need is an incumbent who's popular enough or strong enough to exploit that loophole, and now we have a president for life. And that, again, that's something we've seen in many countries that have purported to have presidential term limits. So the moral of the story is, with all due respect to Senator Magnuson, all other things being equal, when you're drafting constitutional procedures, it's better to make things airtight than it is to make them concise. And that takes us to our last of the 3 amendments today, the 25th Amendment, Section 4 of which was the subject of my most recent book, which is called Unable. The 25th Amendment is about presidential succession and incapacitation. The problem here was a big one. In the original Constitution, the provision for presidential disability was seriously incomplete. All it said was that the vice president would take over if the president suffered a, quote, inability to discharge his powers and duties, the powers and duties of his office. But that was it. That's all it said. There was no standard provided for what counted as an inability. There was no process set up. There was no decision maker designated. And the result of this was, despite numerous incidents in which presidents were completely incapacitated for multiple days, power never once transferred to the vice president. Many people are familiar with Woodrow Wilson's stroke and with James Garfield getting shot and lingering for months in various degrees of lucidity before he died. But there have been numerous other times when presidents have been out of commission for multiple days. George Washington, James Madison, Harrison, Taylor, Cleveland, McKinley, Coolidge, the list goes on. Now, the longest streak we've ever had of presidents finishing out their terms happened at the very beginning of the Republic. We went 13 straight terms before our luck ran out in the 14th, and William Henry Harrison died in office. And when Harrison died, Vice President Tyler took over, as everyone agreed he should, but it was unclear whether Tyler was supposed to become president, as he insisted he had, or if instead he was only the acting president. The Constitution was ambiguous on this point. Now, the stakes of that disagreement were actually pretty low. An acting president has the exact same presidential powers as an actual president. But in any case, Tyler persisted, his opponents backed down, and it established the so-called Tyler precedent, which is that when the president dies, the vice president actually becomes president, not just acting president. This created a separate problem, though, regarding disability, because the Constitution mentioned removal, death, resignation, and inability all in the same breath. It made it sound like whatever you do for one, you do it for all 4. So if the president's death made the vice president the president, not just acting president, that suggested that the same thing would happen if the president suffered an inability. In other words, if the president was disabled and the vice president stepped in, the vice president would become president, and the disabled president wouldn't retake power if and when he recovered. So vice president would already be wary of looking like a power-mad usurper if he declared the president temporarily disabled and took temporary control of the White House, but making that seizure permanent and terminating the presidency of someone who was too ill to work, but maybe would get better after a day or two, that would look even worse. But this presented a problem. Vice presidents didn't step in. They realized this was a problem when Garfield lay incapacitated for weeks before dying, and the country effectively had no president, but nothing was done. 38 years later, President Wilson had his stroke. And people talk a lot about the cover-up, but it was public knowledge that he was incapacitated. His doctor announced publicly that all, quote, all matters of international or national interest will have to be dropped by the president for the time being. It cannot be predicted at present, he said, how long it will be before the president can resume his official duties, unquote. So under the Constitution, clearly, Vice President Marshall should have stepped in. But Marshall was unwilling to do it. The cabinet members pushing him, members of Congress pushing him to, he wouldn't do it. The Constitution didn't provide any process. It was uncertain whether Wilson would be able to return to power if he recovered. Wilson and his doctor and his wife were unwilling to let that happen. Marshall was unwilling to push it. And so the country was rudderless for months. And this was a problem that remained unsolved until the hero of our story, President Eisenhower. President Eisenhower had two things going for him. One, he had a lot of health issues, which helped in this issue of disability, ironically, made him able to fix this problem. And he was a general. And he was aware that we were living in the nuclear age with the new possibility that split-second presidential decisions could save billions of lives. And as a military man, as a nuclear age president, he felt a responsibility to maintain a steady hand at the helm at all times. He also had greatly expanded the role of the vice president more generally. He gave his vice president, Richard Nixon, significant executive branch work to do. And nowadays, people sort of take it for granted that vice presidents are significant participants in governance. But for most of the nation's history, they were these peripheral figures. And Eisenhower made it a priority for Nixon to be ready to step up into the presidency. So in 1955, Eisenhower had a serious heart attack. He was out for weeks. While he was gone, Nixon presided over meetings, but avoided doing anything officially presidential. The next year, Eisenhower got an intestinal blockage, required surgery, anesthesia, complicated recovery. Nixon again filled in meetings, but presiding over meetings wasn't enough. Eisenhower wanted a commander-in-chief in place when he was under anesthesia. So he asked his attorney general to propose a solution, and it was that proposal that would evolve into the amendment. Eisenhower suffered one more health crisis the year after the intestinal one. He had a stroke in 1957. It made him unable to talk. That settled it. He recovered, but he signed an agreement with Nixon in 1958 and made it public. Transparency was very important to Eisenhower, too. The people needed to know that there was always someone at the helm. And the agreement provided for Nixon to step in as acting president anytime Eisenhower declared his inability to exercise his powers and duties. If Eisenhower was incapacitated but unable to say so, then Nixon could make the call after such consultation as seemed appropriate to him. But either way, Eisenhower would retake power immediately whenever he declared that he was ready to do so. Ironically, then, Eisenhower's health was fine for the remainder of his term. He never needed to invoke the agreement. But that first proposal that went to the congressional committee took this informal agreement and put it into the Constitution to make it official. And a second proposal added a provision for resolving disputes. If the president had said he recovered, but the vice president and cabinet disagreed, Congress kicked these ideas around. Not much progress was made until 1933. Two big things happened in, 1963. First big thing that happened was Birch Bayh was elected to the Senate. In his first year, he was made chairman of the Senate Judiciary Subcommittee on Constitutional Amendments. And over the next 2 years, his leadership and drive to get this amendment through would prove decisive. The biggest thing that moved the amendment along, though, was the Kennedy assassination in November of 1963. Public interest in presidential disability and succession and vice presidential vacancies soared, and congressional interest did too. It took a couple of years to hammer out the details, but we already know it already got through. Section 1 wrote the Tyler precedent into the Constitution. So now it was official. If the president died or resigned or was impeached and convicted, the vice president becomes president, not just acting president. Section 1 has been invoked once when Nixon resigned and Vice President Ford became president. Section 2 of the amendment solved a separate problem that I haven't really talked about yet, vice presidential vacancies. Under the original Constitution, if the vice president died or resigned, or if the president died and the vice president became president, there was no way to fill the vice presidential vacancy. And that put some pressure on the line of succession statute. The vice presidency was vacant for those reasons a lot, over 20% of the time. So Section 2 provided for the president to nominate a new vice president confirmed by the House and the Senate. And again, that takes some pressure off of the line of succession. This provision has been used twice, when Vice President Agnew resigned and was replaced by Gerald Ford. And then when Ford became president, he needed a new vice president, nominated Nelson Rockefeller as his vice president. Since Section 2's enactment, we've only been without a vice president for 1% of the time it took to confirm the nominees. Section 3 wrote the first part of the Eisenhower-Nixon agreement into the Constitution. If the president says he's unable to discharge his powers and duties, he hands power to the vice president. Then when he says he's able again, he takes his power back from her. No muss, no fuss. And there have been 3 invocations of that, all during colonoscopies, 2 by President George W. Bush, and one, I'm sorry, I skipped one. President Reagan had colon surgery to remove a tumor. So there have been 4 invocations, and 2 by George W. Bush for colonoscopies, and 1 by President Biden for colonoscopy. That leaves Section 4, the most dramatic section, the section I wrote a whole book about, the one that seems to happen on every TV show and movie about the president. It's also the only one that has never actually been used. The point is to make sure that if a president is unable or unwilling to invoke Section 3, there's still a way to transfer power to the vice president. But while Section 3 was meant to provide swift and certain continuity, Section 4 had to protect the president. The drafters didn't want it to be another way to get rid of an unpopular president or to make an end run around impeachment. So they made it harder to do Section 4 than to impeach and convict. So the way Section 4 works is the vice president and a majority of the cabinet can declare the president unable. At that point, the vice president immediately takes power as acting president. Then, instead of letting the president take back his power immediately when he says he's okay, if he says he's okay, the vice president and cabinet have 4 days to disagree. And during that time, the vice president stays in charge. And if they say he's not okay during those 4 days, then the question goes to Congress. The vice president stays in charge in the meantime while Congress considers the question. But then the deck is stacked very heavily in the president's favor. Unless 2/3 of the House and 2/3 of the Senate agree within 3 weeks that the president is unable, the president takes his powers back. And even if they do agree with the vice president and the cabinet that the president is unable and keep the vice president as acting president, the president is still able, he's still president, he just doesn't have his powers, he's still able to keep coming back and trying again, saying, well, now I'm recovered, and start another round of voting. So the bottom line is that if the president is well enough to contest the Section 4 action against him, he'll probably be able to take his powers back. And so Section 4 isn't going to be used, hasn't been used, and isn't going to be used unless and until the situation is very serious. The president is completely or almost completely incapacitated, with a couple of rare exceptions I talk about in the book. And this effect is bolstered by the fact that the people who invoke Section 4 in the first place are the president's own people, not the political opposition that already wanted him gone. So again, Section 4 is designed to protect the president. Congress does have the power to designate, under Section 4, designate a group other than the cabinet to invoke Section 4, but the vice president still needs to be on board. There's no substituting her in the process. But in any case, Congress has never seriously considered designating any such alternative group. So that's all I've got for you, but I'd love to take your questions.
All right, Professor, you have made us wiser. Now we have to try to put it in context with our questions and answers. Our questions, your answers. So let me kind of tell you we've got a series of questions. One is very straightforward, which I can answer. Someone wanted to know, is the series archived? The answer is yes, it's archived on our website, and the information about how you get to it, it's capitalhistory.org, is in the chat. So if you want to just copy that, you can do it, because the entire series are on our YouTube page. Now, let's talk about the 20th. We're going to do these amendments in order, as you tried to do, and we'll see how this conversation goes. I know our people, they jump around, which is great. For the 20th Amendment, you talked about the House sort of ping-ponging the issues and trying to figure out what they'll do with and what they won't do. Can you explain sort of what were the politics of that whole drama at the time?
Yeah, so the politics were not at all around the presidential part. In fact, in the debates, they often would say, let's throw out the lame duck stuff and just do the president stuff. That part was uniformly popular. The political stickiness was all around the lame duck session. The House leadership didn't want to get rid of the lame duck session because it gave them a lot of power. The people who would be leaving office, maybe they could get jobs in the administration. That gave the president a lot of power. So it was just the status quo. And the reformers, the progressives, like Senator Norris, had been pushing against that for a long time. And again, it wasn't until 1931 when they relented. And part of the reason was the Great Depression. The long lame duck period, waiting for President Roosevelt to come into office, while President Hoover was doing basically nothing, made people realize we need to move this back to January, and that also made a big difference. Events made a big difference there.
Got it. All right, jumping around to the 25th Amendment. Two people have asked, how was it dealt with when Ronald Reagan was shot? You talked about the president having a lot of power. Obviously, in that moment, he didn't have a lot of decision-making capacity.
Yeah, I have a long section on this in my book, because if you ask the people who were around at the time now, or 10, 20 years after, if you ask them, they would say, yeah, we probably should have invoked the 25th Amendment. Reagan was completely incapacitated. He made a big point of walking into the hospital. As soon as he was in the door, he collapsed. He lost half of his blood volume. If he had gotten there a little later, he would have died. He was under general anesthesia in surgery. And so they probably should have had him invoke Section 3. And they didn't because of appearances. The same reason that he walked into the hospital. It was in the middle of the Cold War. Didn't want to show weakness in upper leadership to the Russians or the Soviets. At the time, they were monitoring Soviet military movements. They were sort of freaking out about that. There was also the problem that Reagan was in his late 60s, and his age had been an issue. So there was always this need to sort of promote the image of him as vigorous and strong, and handing over power, even though he'd been shot, would have been at odds with that. But it was there's a lot of behind the scenes drama in there. Fred Fielding in the White House counsel's office prepared the memos so they could do Section 3 or Section 4. And the chief of staff, who doesn't have any role constitutionally in the process, said no, and to get that stuff out of here. And then Vice President Bush was on a plane, and so they didn't have communication. And so you had Secretary of State Haig stepping in and saying, well, I'm in charge here, because he had gone to grade school under the old succession law before 1947, when the Secretary of State was next in line. It was a big mess, and it would have been a lot better if they had just had Reagan sign the paper on his way into surgery, and George H.W. Bush would have been in control, and everything would have been fine. They also made a point of making it seem like Reagan was just fine a lot sooner than he actually was. It took about 3 months before he was really fully able to come back. They should have given him more time.
And I just want to remind people that when we send, when this is over, we'll send a notice to everybody so that they can find the videotape. And in that, we will also highlight your books, which you've referred to a couple times, so that people can purchase them, because I know people are kind of like, tell me the name of that book. What's that? Those will be there. We have one of our listeners indicated that she just ordered your constitutional cliffhangers.
Oh,
and
good.
Talk about self-pardon. So would you like to speak? She's trying to figure out how she's going to explain what are the rules about self-pardoning to her students who are in government in high school.
Well, this was actually the very first thing that I wrote about as a legal scholar, as a law student. It was in 1995, I wrote this. And I think it's important to think about these things before they are live issues, because the Constitution says what it says. It does what it does, regardless of whether you like the president or don't like the president. It's the same Constitution. So it can be very hard to figure out what we think the Constitution actually means if we know whose axe is ground by that. If the president, there's so many arguments you can make in constitutional law, it's very easy to pick the one that makes your side win. So it was important to me to think about it before that. And of course, it's a classic lawyer's answer. Someone says, can the president pardon himself? The answer is, it depends. He can try. My article in 1995 gave what I thought was the strongest argument that the president does not have that power. But that is an argument that a court would have to decide, because the president could try. He could purport to pardon himself. I'll give you just a very quick argument on each side. The argument on one side is, it doesn't say he can't. It says the president can pardon federal offenses, except in cases of impeachment, right? So it's just the criminal justice process, not the impeachment process. And that's the only exception. So he can pardon anyone else that he wants. Simple argument. It doesn't say he can't. The argument on the other side is a little more complicated. It draws on principles like you're not supposed to be the judge in your own case. At every other stage in the process, if you're going to get a criminal punishment, it's going to be because the prosecutor decided to prosecute you, the judge decided to let the case go forward, the grand jury decided to indict you, the trial jury decided to convict you, and the president decided not to pardon you. And you can't be on your own jury, you can't be your own prosecutor, you can't be your own judge, so you shouldn't be able to be your own pardoner either. It's just a bedrock principle. The other argument, which is a little more intricate, but addresses the, well, it doesn't say he can't argument, is that a pardon has to be a pardon. And what I mean by that is there are limits inherent in the definition of a pardon. So for instance, you can't pardon someone in advance. The courts agree, everyone agrees, you can't say the thing you're about to do, I pardon you for that now. You can only pardon people for things they've already done. It doesn't say that in the Constitution anywhere. The reason that you can't pardon someone for things that are in the future is that wouldn't be a pardon. And my argument is granting someone a pardon inherently is a bilateral thing. It's not something you can do for yourself. So if you look at the Latin root, perdonare, donare is in other words like condone or donate. You can't make a donation to yourself. You can't condone your own actions. It doesn't make sense. It's not a donation if you do that. Similarly, if you purport to pardon yourself, it's not a pardon. And granting a pardon, if you grant something to someone, that you can't grant something to yourself. So there's that linguistic argument. But the bottom line is no one knows, and no one will know until a president decides to pardon himself and or herself, and then prosecutors go after him or her anyway, and then the court will decide. But those are the arguments on both sides. And the book, there's a chapter in the book that presents both sides, not just the side that I agree with.
And how has that been impacted by the most current Supreme Court justice or Supreme Court ruling about presidential immunity?
Well, it takes some of the pressure off because the more immune presidents are, the less need they would have to pardon themselves. So it would make it easier for courts to say that they can't pardon themselves because they shouldn't have to. But it doesn't completely resolve the issue. There's still potential for a president pardoning himself for unofficial actions.
And so go back to a different question. If there's not a vice president in office, who presides over the Electoral College certification?
So traditionally, it's the president pro tem. Article 1, Section 3 says in the vice president's absence, the president pro tem of the Senate presides. It says that the president pro tem presides over the Senate, though. The 12th Amendment doesn't say, but that has been the practice by analogy to other times that the vice president is absent. The president pro tem does it and has done it many times.
And let's just go back to the 20th Amendment for a minute, because it just is so interesting to have this long lame duck session and the whole dynamics about if something gets thrown to the House. Why was it set up to wait until March 4th? What's the history about that?
Yeah, it was just an accident. The Constitution didn't know. They didn't know when it would be ratified. So all they said was when 9 states ratify it, then it becomes effective. But Congress will have to set a date. And so the old Congress, the Articles of Confederation Congress, did that. It just so happened that it was summer of 1788 when that 9th state ratified it. And so they said, well, we need time to have elections. We need time for people to get to Washington. Let's say March 4th. And so it was somewhat arbitrary. It wouldn't have been a problem if the Constitution hadn't said first Monday in December is when things convene, or if they had had the elections later than November. But there were reasons for having the election in November, and there were reasons for having the session convene in December, mostly agricultural and travel related. So we got stuck with that. I think if they had said things start not on March 4th of 1789, but December 4th of 1788, then we wouldn't have had this problem.
And so, and also you talked about Section 3 of the 20th Amendment. If a president or vice president fails to qualify.
Yes.
I mean, who decides whether they qualify?
Very interesting. So that phrase, fails to qualify, is what led me to, it's actually my next article. It's in production right now with the Cardozo Law Review. So it'll be out this fall. But it doesn't say, the language of it doesn't say if the president-elect and vice president-elect are disabled or the election isn't resolved. It doesn't get specific. It just says fails to qualify. And you can look at that language and say, well, maybe that means qualifications like you have to be 35 years old, you have to be a natural born citizen, you have to have been a resident for 14 years. Maybe that's what it means. But and I wanted to know, what does it mean? So I looking at the legislative history, the drafting history of the amendment, it was meant to cover everything. The point of failing to qualify is that you are not taking the oath of office and entering into the office. And that might be because you haven't been elected, no one's been elected, so no one qualifies in that sense. It might be that you are dead. It might be that you're disabled and you can't take the oath. It might be that you decided you don't want to be president or vice president. Those are all ways to fail to qualify, in addition to not meeting the constitutional qualifications for office, like age, residency, and citizenship. Although there's no process for determining those things, there's not really a process for determining disability either. But that term, failure to qualify, was meant to be a catch-all. And unfortunately, it requires digging into that legislative history to find that out. But hopefully when my article comes out, everyone will read it. And then if this ever happens.
And both sides will cite it, just like in the Trump story.
Yes. So, well, that's another chapter in the book. Can you impeach people after they've left office? I wrote that one in 2001. Again, best to think about these things before they come up so that you have an honest answer.
Well, this has been fascinating. We're coming to the end. We could keep this going forever, but we're not going to. We're going to call it. So here is my question. We've just talked about 3 amendments that were supposed to sort of smooth out the issues of concern that the public had, that we saw as we exercised the office of the presidency. We're entering into a challenging electoral moment. What do you think might happen that is not addressed by these amendments? Are there things that we do need additional amendments to address, or is this all set forth and so no matter what happens, we're set, we can figure it out?
There are a lot of things that I think could be, and this is my next article, I'm trying to write this summer, but it's getting away from me. Summer is. There are a lot of places where I think Congress has the power to legislate some of the details and should do so. So, for instance, the 25th Amendment covers when the president is disabled, is unable to discharge the powers and duties of his office. It doesn't say anything about the vice president. It doesn't provide for succession past the vice presidency at all. So if we have an acting president and that person's disabled, we have no process for sending it down the line to the Speaker of the House. And I maintain that Congress has the power to legislate in that area through the necessary and proper clause. They could provide standards. They could say something like the 25th Amendment process applies. It's just the next in line instead of the vice president. Whoever's next in line plays that role. But without any standards in place, I think we have a real problem. But I think the biggest problems are those. The Constitution, it would be nice if it designated decision makers here, but things like disability, counting electoral votes, the 12th Amendment, that's still a mess. But I think they just need to use their power. The 20th Amendment, Section 4, the death of a finalist in the contingent election, very dangerous situation, tremendous incentive to assassins, I hate to say it, because at every other stage in the process, you just get the vice president. At that stage in the process, you could take one party out of the election. And so the incentives are terrible. And they need to remove those incentives. They could do it by passing very simple legislation. I drafted it, put it in the article, and they've introduced some bills since then, but hasn't gone anywhere. And so I think I know it's hard for Congress to be proactive, to deal with hypotheticals instead of the things that are actually happening now. But I think these are things where they really need to. The only option is to be proactive.
Well, Professor Kalt, you have given us a great deal of information and also a lot to think about. That's what we do here at the Capitol Historical Society. We provide public history for our audience, and we are so grateful to each of you who is on the call today. We hope that you will share this with your friends and neighbors. We remind you, as we always do, this is only possible because of the support and the generous donations that come from our members and donors. We are chartered by Congress. We are not funded by Congress. We are funded by the energy and gifts of our supporters. Professor Kalt comes to us on his own time as a part of his gift to teaching informed patriotism. So we thank you very much. As we look forward, Vincent's going to put the coming up screen. Our next in this series on the constitutional amendments is looking at expanding the right to vote, the 23rd, 24th, and 26th amendments. And we will talk about that process and why we expanded the right to vote as we are coming on an important election. As you can see, all of our previous webinars are all there on our website. You can get to it from our website or go directly to our YouTube page. And you can also take a look. If you're a QR code person, you can scan this QR code and learn more about these programs and register for the upcoming events. Professor Kalt, thank you, thank you, thank you. We are so grateful to you for your time, your talent. We will make sure that people have information you will send us about how to keep in touch and see your books and your articles as they come out. Take
Yes,
care.
and I love answering questions. If people have more questions, feel free to email me, and I'm happy to respond.
All right, spoken. You know our people. They might ask questions, so we'll include that in the follow-up. Thank you so much, Professor. Thank you all. Be well. Have a good day. Goodbye.